Koyama. I'm appearing myself, and
we'll just get counsel on the other side announcement because
Please, Your Honour, Collins appearing for the respondent.
go ahead, counsel, please. Just so you understand, we have your written material and we have 15 minutes time.
I submit material, case material, and the filing of the issue at this point is whether the filing is on time or not. And the objection of the respondent is that this appeal should not be heard because the application for the appeal was not filed on time.
I think you should, I'll just ask my colleagues to intervene if I disagree with this, but I think you should concentrate on what is the reason you should be allowed to argue the appeal. Because if you have a good reason to argue the appeal, then I think we will give you an extension of time. So let's focus on what is the basis that you want to argue your appeal.
My argument is the filing of the need appeal was on time, so therefore no need for extension. And my argument is supported by the letter from registrar.
I'm saying you don't need to argue that. If you've got a good basis for appeal, then we will give you an extension of time. So you don't need to worry about whether the registrar was right or wrong about the time limits. Okay? Just you tell us why it is that the appeal is an appeal that ought to be brought to this court.
Yes. I didn't say it in my notes, application to this appeal. The issue of prosecution was significant, and first of all, at the Human Rights Tribunal, the judge, the chairman of the tribunal, was a practicing member of the respondent, and that caused the appearance of bias. In fact, a tribunal composed of the chairman and 2 other members decided the case without having a hearing, even though there were factual disputes in the case. Another thing would be the case was decided after the respondent failed to submit the counter argument on the submission that appellant submitted. And the time sequence is more like tribunal simply stop the process with that goal.
Remember today, all we decide is whether we give you leave to appeal.
Right.
And so what you need to persuade us is that the matters that you want to raise are matters of importance, that are important. They are questions that need to be resolved because there is a public interest in resolving them.
Yes. My submission is the respondent should be liable for the action that former country district legislature did. The reason being is the respondents had the asset and liability of the country district society transferred to the respondent. Therefore, appellant has the right to pursue grievance and complaint and also claim against the respondent. And that's the basis of the appeal. Also, under appeal, the respondent will do is the Human Rights Tribunal, according to the Human Rights Act, substantial merit of the case, which at least for common people who think that must be the impartial tribunal. Also, there must be hearing, especially there were factual disputes. Also, both parties submit to have a hearing. It doesn't, at least doesn't serve anybody that simply tribunal stop in the middle of the proceeding to give a judgment when I submit and the respondent didn't submit it. And suddenly stop the proceeding, and that's how it happened on the July decision. And there was no hearing. Also, there was no reply by the respondent. So, this injustice has been done by Human Rights Tribunal, and that's the reason why I responded. I apparently argued for the bias of Jeff Person from the beginning, and through the High Court and also the Court of Appeal, as a part of the argument that Court of Appeal should run, because prosecuting member shouldn't be judging a case, because prosecuting member and both sides they feel same party. So, but there could be some arrangement could be done, but certainly the respondent member shouldn't be a judge, because the interest, also the camaraderie, everything is part of it. So that was the first problem that happened at Human Rights Tribunal, and that made me so.
Well, you talked about the New Zealand Society being responsible for the liabilities of the Canterbury Society.
Yes.
And you said that's an important, that's the
Yes.
basis, you said that's the principal basis of your intended appeal. Why do you say that's a matter of public importance, given that is now a historical event which might happen again? Why is that a matter of public importance?
This is the merger case. It's the public interest to know whether the incorporated society can merge without having assuming the liability.
This was done by legislation. It was a one-off, wasn't it? This wasn't just any merger of an incorporated society. It was actually an act of Parliament that brought it about, wasn't it?
After Parliament, according to the authority, it only said there would be carried forward to New Zealand Law Society any liabilities and also the proceedings. If the proceeding was happening, it would be carried to New Zealand Law Society. After Parliament, they would say that give you that immunity once the merger is done. After Parliament is clear from the statute, which is part of the commission, that it carries over. It didn't say if you don't bring it proceedings before the January 31st of 2009, it will be void, or it didn't say that if you bring it, it will be carried over. Intention of Parliament and also text from the statute is clear. Everything will be carried over to New Zealand society. Liabilities, proceedings, all that. But there is no...
But your proceedings were not pending before January 2009, were they?
No. That's the reason why Appellant argued that Section 338, Section C is not applicable, because there was no proceeding. So this section that Human Rights Tribunal and also High Court derived wasn't even applicable. There was no proceeding at that point. No.
Well, if you didn't have a proceeding in place, how could it be carried over if there wasn't one in existence?
Yes. The Appellant argues that Section 378 1A actually says that liability charges would be carried over to the respondent. Section 1A. So liability, responsibility, all the charges, obligation, everything that comes to the society accrued would be carried over to the society. Appellant argued that Section 378 1A is applicable in this case. Therefore, asset liability will be charged with the liability from the common district law society. Therefore, the respondent has the obligation to respond to the complaint.
What was the liability of the Canterbury Society to you on the 31st of December 2008, the day before it merged with the New Zealand Society?
What the common district law society...
you didn't have an extent claim.
Not the claim. I complained to Human Rights Tribunal, the Privacy Commissioner.
But you didn't have a claim against the Canterbury Society. It wouldn't have had to report on its books that it had a liability to you.
Yes, it's liability because I was applied to... My personal information was collected with the amount of authorization secretly by the candidates for Friday used against me and refused to issue certificate, and I was forced to leave the Christ Church with no fault.
No, I'm just going to hit the word liability.
Yes.
It means an obligation to pay money.
Yes, of course.
It didn't have an obligation to pay you any money.
Certainly
It's
that.
not merged,
No, they do. The damages have been happening to the candidate society.
Yeah, but you didn't have a claim.
Of course, I claim to the Human Rights Commission, also I claim to the Privacy Commission. The problem is still, candidate society sent a false letter to the Privacy Commission to stop the investigation. Also, Human Rights Commission, I complained that.
I think you should be careful about making those sort of accusations. You're in a court of law now, you've got to conduct yourself properly. You should be careful about that.
I have the evidence.
Make sure against the rules.
I have the evidences that are available. That's the reason why we should have the hearing, so I can show all the evidence. I already submitted evidence to Human Rights Tribunal.
Well, you already have an appeal about Michael. All right, so your point is that the question of the interpretation of the Section 378 as a point of public importance, you would say, is that?
Yes.
Okay. And then you talked about the obligations of the tribunal. What's the point of public importance in relation to the tribunal's conduct? Yes.
According to Human Rights Act, they have the, according to natural justice, with impartial, must be, the trial must be impartial, also must have a hearing to find out what the facts are, especially the facts of disputes, because also the both parties submit that hearing must be held. The tribunal must have done hearing. Also, they must have done the discovery, which is tribunal send us a letter to say they would do the discovery before the hearing. They didn't do that either. So that's against the public interest, because public expect that tribunal have that fair, impartial hearing with the, I mean, that's the basic of the trial process, I believe. And the Human Rights Tribunal didn't do it.
Okay, so you say the 2 points on which you should be doing the 378 and the proceeding, the way the proceeding was conducted in the tribunal.
Yes.
Are those the 2 points you want
Yes,
to
yes, yes.
Is there anything else you want to add? Or please need to give Mr. Cole a chance to listen.
Yes, so those are three issues.
Thanks very much, Mr. Cole.
Thank you, Ross. I have in my written submission set out what I hope is a helpful chronology of events which I describe as undisputed factual background and key litigation events. And first round proposing that this special leave application was out of time. And I submit that the fact that it was outside the 21-day period is incontrovertible. The judgment of the High Court Justice Coach dismissing the application for leave.
Well, I'll just repeat what I said to Mr. Koyama, which is he was a few days out at most.
Right,
If he's got a good case, we're not going to stop operating.
so I have acknowledged and do now acknowledge that if there's merit in the appeal, then I suppose it's likely that the time obligation, so time of objection will slip away. So I will now focus on the lack of merit in the appeal, and Mr. Koyama has helpfully confined, or as the arguments he says he has, to section 378. It appears, I understand, it was admitting, as he acknowledged to, that there were no proceedings pending, so against the Canterbury District Law Society at the time that entity ceased to exist by statute, and that occurred at midnight on the 31st of January 2009. And whether we're talking about current and unresolved complaints or actual proceedings before the Human Rights Review Tribunal or elsewhere, there were no such thing. And it's not advanced, as I understand, Mr. and he has consistently and clearly not tried to say that there was some complaint. He had demonstrably withdrawn his complaints during the sunset period of the County District Law Starting in September 2008 and not renewed them, much less going proceedings. So he is then driven to the notion that he has tried to advance in the High Court as well, that in fact what he's talking about is the liability of the County District Law Society, and I submit in the court already.
It's a potential liability for a proceeding he hadn't brought.
Yes, well, I say, sir, it's a potential liability for a grievance in the mind of the individual, nothing more. If your Honour has specific
I thought he didn't concede that he had no proceedings against the Catholic Society on the 1st of January 2000.
I thought he had. I noted him down as saying that you said there was no proceeding to be carried out.
Yeah, but I thought he said he did have complaints that hadn't been withdrawn to the Privacy Commission on the Human Rights Commission.
well, there's an limited factual record for this court, I acknowledge, that the facts are correctly recited in the High Court judgment of Justice Thompson, and that there was an email on the September saying complaints dropped. It was headed complaints to the Privacy Commission, the Human Rights Commission, and it said in substance complaints to the Privacy Commission, the Human Rights Commission had been dropped. There is no record of any other complaint, much less formalised final proceedings. There was the only twist in the tail, so to speak, was a reference to correspondence with the Human Rights Commission subsequently, and that is why the HRRT distinguished between dismissing the Privacy Act, as it were, outright, and striking out the Human Rights Act, proceeding with the ability to bring those afresh if Mr. Koyama was capable of showing he had a live complaint at the time, he simply never has. And that status remains open to him. And he has neither produced in the appellate context or going back to the Human Rights Commission or the Human Rights Review Tribunal any extant complaint against Canterbury District Law Society or against New Zealand Law Society at any relevant time. Other than those described as dropped. So I submit that the High Court, and again on two occasions, the hearing of substance of the appeal and the hearing of the application for leave, correctly understood the facts as I've explained them. And then with regard to the liability issue, whether it's simply not liability, then when we get to the complaints that I'm calling grounds about the processes followed by the Human Rights Review Tribunal. Now,
Well, I'm just putting on that. Why do you say the question of whether Section 3785 is not a point at which you agree?
Almost, because it is purely a matter of private concern to this litigant or would be litigant. There is no, and that in the nature of I'll call it a personal grievance, I understand that term, but a grievance of a personal nature about a body now long out of existence, in respect of which the courts have heard this, are able to see for themselves that the real remedy to a person in the applicant's position was to become admitted, because that's what he was seeking, and he was in fact admitted as a result of the certificate of character issued to him by the Otago District Law Society. He was admitted on the 1st of May 2008, and in my submissions I described.
I think or 7.
I'm sorry. It was, it was 07. It's recorded in Justice Johnson's judgment 1 May 07, sorry, that was the correct date. So I've said that neither in terms of principle, which might be important publicly or beyond the scope of this, the defined facts of this case, or in terms of the meaningful remedial justification, is there any interest, I submit, of a private nature, let alone public. And to add to that, in terms of the public interest, let's say there was an interest in interpreting and applying an aspect of the provisions for the transition between two pieces of legislation governing the legal profession. We are now, since 1 August 2008, going for 5 years, and the experience of the regulator and the courts will be that those sorts of issues are now disappearing in the distant past. So I submit that there's no interest, public or private, of the sort discussed in cases like Dawson that justify the continuation of this matter, and indeed it's my submission that it should be brought to an end.
Now, what about the complaints about the conduct of the tribunal?
2 points about it. First, again, this particular document is not before you, but the Human Rights Review Tribunal made a decision on the bias issue, and that was dated the 18th of February 2010. It's named Koyama v. New Zealand also 2010, HRRT 2, 18th February 2010. The issue there was that the applicant objected to the then tribunal chairperson continuing to sit in this matter because he was a member of the New Zealand Law Society, or had been by virtue of his status as a barrister and solicitor, and with a practicing certificate. And
does the statute say that the chair has to be a barrister and solicitor?
Yes, or a district court judge. My foremost submission on this is that it's irrelevant to the present legal application because it was the subject of a decision of the tribunal which itself was capable of appeal but which was not appealed. So
The fact that Koyama says it wasn't capable of doesn't make it Julia's reply to the material code.
yes, but the simple fact that I mean, I had sought to avoid, because it was done on this court, a large body of material which was thought not to be relevant, but I feel, and of course will provide the HRRT decision on the bias issue. And simply it was not appealed, time elapsed, and we proceeded in terms of having case management conferences and the like, then progressed to the protest jurisdiction stage, and that decision was in July 2010, and that was appealed, and that took us to the second process objection that matter was heard on papers. And as long as Justice Dobson traversed that issue in his judgment, in my submission, respectfully, correctly, that it was a matter capable of being heard on papers in the manner that the Tribunal Court did, and there was a case management conference note recording what happened, and the applicant had consented to that procedure, and provision was made to back to a hearing in person situation of any issues of fact appear to be likely to arise, and none did. So it was an unobjectionable process in which the decision purely was a matter of law about the issue. Now, which I say is a sole issue capable of being clear, should be granted, was dealt with in papers within the jurisdiction as set out in the judgment of Justice Dobson. So my submission underlying all of this is that while there was an attempt to continue to litigate past matters not available, and one would see also from the judgment of Justice Dobson that there was, for example, opportunity given by his Honour Justice Ben at a case making conference for the applicant to treat this as a judicial review application. And he specifically refused that invitation to series an appeal. The attraction of judicial review was, of course, the focus turned on the matters of process, which at times
what your position is that these either are not amenable to appeal now, or they're not matters that should be accepted or received determined by the High Court.
But as to the matters of process, they are not amenable to appeal. As to the matter of the sole point of law about whether or not there was a proceeding available to be continued over against NZLS, that matter has been adjudicated upon properly. My submission, and there is no public or private interest warrants further get to the second appeal. Unless there's some question.
Do you want to reply to anything that Mr. Collins just said, Mr. Brown?
First of all, my understanding is those on the memory cases are dealt with issues of extension for the both appellants either file or say paper on time at the High Court, and this case is different. High Court everything's on time, and my understanding even court of appeals on time. Okay. Then another issue is, as I stated in my memorandum submitted, I have complained to the private commissioner continually after this September. And the private commissioner sent a letter when the litigation started, says there is no problem with this issue. Only thing is that they didn't complete the investigation. That is the only thing that they got on the letter. They didn't say anything about withdrawal compliance, nor anything about any invalidity of the complaint. Simply they said we didn't complete the investigation.
Just so we understand, the point you want to argue on appeal to this court is that the Canterbury Society had a liability to you, and that was carried over to the New Zealand Society. And that's the point.
Yes.
So all we need to decide is that a matter of public goods, not whether you're right or wrong.
Yes.
Whether it's a matter that this court should trouble itself with given all its other obligations, because the argument against you is that you're the only person who's interested in this thing, nobody else is interested, and therefore it's not a public issue.
This is the first case of the merger of incorporated society.
Well,
Certainly case law is there for business.
it's not a merger of incorporated society in the normal way, is it? It's one done under a particular piece of legislation that created its own special law.
Then a piece of protest, a liability and assets have been transferred from the country society to internal society, crystal clear, the liability and both. There's no anywhere in the provision says the act is given immunity to regional law society. Nowhere. The law society hasn't pointed out. I checked every single provision. There's nowhere there can be any interpretation can be made say that act could possibly give immunity to the law society. So only
Again, I'm not interested in the merits of that. I'm just interested in why this court should deal with that point. If in fact the only remedy you would obtain if you were successful would be your admission as a barrister and solicitor, and you've already got it. What else could you get?
I possibly seek for general damages because my
damage when you got admitted to the bar a few months later.
No, she was 1 year. Also, the location is different. It's not the Christchurch where I intend to practice law, but in the
once you're admitted to the bar, you can practice anywhere.
Certainly, I was denied in the Christchurch. I was forced to move it to the meeting due to the violation of Human Rights Act, also the Privacy Act.
And once you got admitted, you could have moved straight back to Christchurch again and started practicing. Couldn't you?
Whether I could or not is not issue. Issue is whether the Country Society violated the Human Rights Act 1993 and the Privacy Act 1993, and I'm a victim, have a right to bring the complaint and heard by the impartial tribunal, which hasn't been done. That's the issue. And that's the public interest of this case, that people in this country, also internationally, want to see justice being done, heard. Whether the country society actually violates the law or not, we haven't.
But in the end, appeals to this court on a second appeal basis only by leave, and there's a very stringent test. And yes, there is an interest in making people comply with the legal obligations, but we've already had an appeal, and this court only does a second appeal. It's a matter of public importance. And so what I'm asking is there anything important from a public point of view other than that you just feel very aggrieved? And that's not a public issue, that's just your private interest.
As I said before, human rights tribunals have to be impartial, conduct in impartial way, which is the public perspective.
On that basis, every human rights tribunal decision will be subject to a second appeal. There has to be some which don't get a second appeal. The law says we only give it to ones that have a particular public importance.
Certainly, well, there's one issue that I believe is the Justice Dobson said himself that he invented an issue on the bias. The problem of this method is the bias issue was raised by Appellant, and also this issue was argued by the respondent as well. The both sides argue on the bias issue. Actually, the respondent said bias issue must be heard in the High Court. That is the
you're off the topic, I think. So if I understood you correctly, your argument is in relation to Section 378 and in relation to the conduct of the tribunal is that there is a general interest in those bodies being held to act in the tribunal being held to act in a proper way. And in relation to Section 378, you say there's a public interest because you could possibly have a damages claim.
Yes.
Is that that's the only public interest you have in relation to Section 378?
I expect all the public interests of New Zealand society are the sole, exclusive, regulated lawyers in this country should comply with the law. And that's public expected. Lawyers from various access, liability, and asset transfer in the society, public expect the law society to be more honorable. So we take the responsibility of the country society, the emerging here. The public expects that. The public see this case as whether the law society takes responsibility. that's public citizen, and that's important because the judiciary and the law society are exclusive service providers. The service and public expect it to be at this place, and that's public interest. Because of the position of the defendant is one and only regulator of lawyers, and the public expect much higher standards done. Thirdly, some company that escape or whatever deal they cannot do. Not law society.
Thank you. We will reserve our decision for releasing information.
Okay.
Stand.